webinar today. I'm Amy Peters from Beneficial Trust and Will Company, and today is just to give you a little bit of an insight into estate planning in a changing landscape, because nothing stays the same, does it? Certainly a constant period of change that we find ourselves in, whether it's government issues or international or whatever it might be, all have an impact on our clients. And then changing legislation, court cases, best practice, all influences how we can advise our clients in a more comprehensive way. So just to tell you a little bit more about us, for those of you that don't know me or not familiar with us, I know there's a couple of people on the call whose names are familiar to me, who we've worked with previously, but we've been established for is it 27 years? I'm not sure now. A long time. Anyway, we're a family founded business. I've been with the firm for the last 12, 13 years. I'm a chartered member of the Chartered Institute of Legal Executives. I'm also a member of STEP, a member of the Institute of Professional Will Writers, basically any membership body I'd like to join, which can be interesting when they do their regular audits. But we fundamentally specialise in all aspects of estate planning, so supporting advisors such as yourself to deliver a really holistic service to your clients. Whether that's straightforward wills, whether it's more complicated planning, we can cover all bases. So everything from wills, will trusts, lasting powers of attorney, lifetime trusts where appropriate. We're not big power sellers of those at all, but they do have a place for some clients. Probate services, estate administration. We also work closely with the likes of specialist chartered tax advisors, where you have clients with quite complicated affairs, and obviously specialist lawyers and solicitors dealing with particular aspects of estate planning or estate administration and so on. So we've worked quite hard to build that trusted network. And really the business, as I say, was founded on supporting advisors such as yourself, who would kind of have the annual review with clients, and they'll say, you'll say, have you made your will? And they'll say no, and you'll say, well, please try harder, make sure you've done it next year. And then you'll have the same conversation with them. So the way that we tend to operate is a couple of routes, which I'll talk about in a bit more detail later. One is a referral route. So if you want to pass clients on to us for us to potentially deal with directly, we can, and obviously keep you in the loop. If you want to have more involvement and look to take instructions yourself, then we can provide guidance, training and support in order to do so. But as I say, we cover a wide range of services. A lot of people kind of say, well, it's just a straightforward will. It's not that complicated, it's dead easy. Yes, those are the famous last words, aren't they? It's when you kind of get a client that says, I just need a straightforward will, let's not worry about my kind of 5 children from 3 previous relationships and my property overseas and my buy-to-let portfolio and my business interests and, that person that I don't speak to and despise. Don't worry about that. It's just a simple will. In some instances it is, but more often than not, there's more to this than meets the eye. And I think fundamentally, if everyone could get along, then we wouldn't need people such as ourselves. But unfortunately, when money and property gets involved, it's about setting the boundaries, setting expectations, and ensuring that clients' wishes can be met and delivered. So, you do all that work with clients to make sure they're maximizing their wealth during lifetime. It's just not good enough for clients to kind of say, well, it's somebody else's problem, hopefully everything will be okay. That's not good enough. It's just an administrative process that we can support them on, just to get these key documents in place and this key planning in place. So that's just a little bit of an insight into who we are. We're going to talk about a few things today. We're going to talk a little bit about the pension changes in terms of inheritance tax, more from a view of how that's going to impact estate administration. I'm not going to dwell too much on that, because you are way more knowledgeable in the area of pensions. You guys will be more than me, and also I'm sure it's been done to death a little bit over the last year, but it's more about the practicalities in terms of you giving some signposting to clients when you are reviewing their overall position, whether you deal directly with their pensions or not, just to give you a bit of an insight as to how much of a problem these changes potentially can be in the future. So we'll go through that. We'll talk a little bit about a recent case that's been going through the courts, which is the McDougall family dispute. Quite a cracker, all sorts going on with that, where a estate that was thought to be worth about 5 million seemed to be about 2.5 million on death due to some financial decisions of an attorney who was acting under a power of attorney. So we'll talk about that. We'll also talk a little bit about will trusts, so things like property protective trusts, these mechanisms that are included in wills to ensure assets pass how the clients would wish after death. We'll talk just at a high level in terms of how are they actually effected after death, how do they come into being. And then we'll talk a little bit about a couple of ways that you can work with us if you wish to support clients with their estate planning. Any burning questions before we get going with all of that? Quite a lot, isn't there? No. So we're all having a nice slurp of our tea, which I will do now. So as we all know, or many of us will already be aware, you don't need me to tell you, the changes that are incoming in relation to pension and inheritance tax are going to have quite a big impact on many individuals and their estates in the future. So many more estates are naturally going to fall within the inheritance tax net. I think it's going to be interesting to see how it influences behaviours towards pensions, and I certainly appreciate that maybe the intention was never for them to be, an outright inheritance tax planning tool for many. That has influenced their planning strategies in the years leading up to this. So it has come as quite a shock, I think, to some clients where their position has changed quite significantly in relation to inheritance tax. And there's a few things that obviously, as well as the actual kind of money side of things, whereas some estates would have fallen out of the inheritance tax regime and now they don't, it's thinking about it in a little bit more detail, such as, who are the pension nominations or the nominees going to be, who are they going to be the beneficiaries of those pension funds, and it needs to be more clearly interwoven with a client's overall estate planning strategy. As I say, there's going to be a large number of estates that are going to be affected. There's all sorts of figures being bandied around, 50,000 additional estates, 40,000 estates. There's a mixture of figures, but some of the main issues from our perspective as an estate planning business, some of the issues we'll come across is how this is actually going to play out in the estate administration process. Some of you may have the joy of dealing with various pension providers and may have good experiences or different experiences in terms of their speed and in responding to requests. My understanding is that historically they're not always the most speedy or responsive, which is going to provide difficulties when we've got things like grants of probate to apply for, inheritance tax to calculate and to pay. So it's certainly going to have, a much bigger effect, I think, than some do appreciate. I think it is going to add complexity as well for lay executors. So as a business, when we draft wills or advise clients on wills, we don't mandate that people appoint us as professional executors or our partner solicitor. And I'm sure that's not great for us in terms of kind of strategic business planning. I'll certainly not be retiring anytime soon. But from my perspective, the client appointing people they know and trust to act as executors gives that estate in the future the option to, at some point in the future, choose if they want to appoint a professional or not. Because there are pros and cons to appointing professional executors, as is kind of fairly well publicised. And I think it's about executors having that option to choose in the future. Now, with these changes, I do think that lay executors, so people who are not professional executors, so sons, daughters, family members, are going to find it more and more challenging to complete the probate process themselves. So I think this has added an extra burden and an extra level of complexity for those people. Obviously, there's lifetime strategies that you'll be speaking to clients about in relation to their pension planning. So often when clients come to us, if they come to us directly, they may not have a financial advisor. These are kind of questions that can crop up when we're looking at their overall estate valuation. Do you have a pension? Have you had a recent review? You've got an inheritance tax liability. How are you looking to deal with that? And then that kind of leads to us connecting that client with a IFA or a professional advisor, because we have no feet, shall we say, in any FCA regulated areas, and we have a clear red lines where regulation starts and end. But for us, it's all about giving the client some ideas where they can then go and speak to professionals such as yourself to take a more proactive approach to their wealth strategy in the future. Whereas in the past, they would have maybe just let pension pots sit there all over the place, which is another issue. Various pots that have accumulated over the years without being particularly proactive with it. So with every change in legislation, there's often some negatives. For you, there's definitely going to be some positives, because clients are going to need a lot more advice in this area, and are going to need, professional advisors to guide them through this minefield. Because it's not just about some of those lifetime strategies to mitigate things like inheritance tax, but selfishly, from our perspective, it is about encouraging clients to get their affairs in order sooner rather than later, and particularly where clients have got multiple pension pots. It's not necessarily an issue, and there may be good reasons why you've advised them to keep those multiple pension pots, but the challenge can be identifying them, because moving forward, those are going to be taxable assets that we'll need to consider in the future. So, for example, where we've got Bob, such an imaginative name, within the scope of his estate, he's passed away. He's got a mixture of property, savings, investments, and then he's got 3 pension pots, all totaling £200,000. Now, of those pension pots, when we're completing the estate administration, without getting too far into the nitty-gritty of it, the IHT apportionment is going to go across those pension pots. So it's really important we have all of the assets identified early on, because when we do the HMRC return for estate administration, we're going to clearly identify where the IHT liability sits and who needs to pay it. So, for example, with the administration of Bob's estate, 2 to 3 months after his death, in terms of a timeline, I should say, his personal representatives are going to be identifying, if there's a will, who the beneficiaries are, if there are pensions, and they're going to look to contact the pension funds to release potentially some of those, to identify the value, and to be prepared to release some of those funds. They'll need to submit things like the IHT 400. So HMRC obviously like to have their payment and work out the apportionment of IHT, and then they'll make the application of a grant of representation. So we're probably kind of 4 to 5 months after death at this stage. 6 to 7 months after death, we might get the grant of probate or the grant of representation through. And so at that point, the personal representatives can look to kind of close bank accounts. They've already done the account to HMRC, so they can identify who the beneficiaries are and think about distributing the estate. So we're kind of 7 to 10 months down the road. But during that time, things can change. So, for example, within Bob's estate, there's a property worth 350,000, according to what has been submitted to HMRC, but actually it sells for 360,000. And then it comes to light that Bob's owes the care home £5,000, so there's an additional debt on the estate. And so then a corrective account has to be submitted to HMRC in relation to that. And then the IHT apportionment has to be recalculated again between the free estate, so money and assets, and what's in the pension pots. And so it may be that 14 to 16 months after death, there's a slight refund on the tax that's already been paid for various reasons, because money's declared or more or less or whatever. So the personal representatives will chase the revenue around 100 times to try and get a refund on the inheritance tax has been paid. But then it's identified that the client had another investment account worth £50,000, and we're now 16 months after death. So for whatever reason, that's come forward. So then we have to reapportion the IHT liability. The problem with that is some of the pension funds will have already been paid out to the beneficiaries. So the executors are going to have to go to those beneficiaries to ask for more money for the inheritance tax bill, money they've probably already spent. So I can put together this outline for you, but you can already start to see the issues with either not clearly thinking about who nominated beneficiaries are for pensions in conjunction with the overall estate planning, in conjunction with wills, trusts and LPAs, having multiple pension pots, and then also identifying all of the assets, being absolutely clear what people really have, because if we have to go back and forth and make corrective accounts with the revenue, that could be problematic. If an executor has to go cap in hand to beneficiaries for more money to settle unexpected inheritance tax bills, that's going to be a problem. You know, the distribution of an estate is going to take much longer than before. So it really is going to be interesting how pension providers kind of respond to this, because there is going to be a big reliance on them responding very quickly to requests for information. And as I said at the start, I don't think they're known for being particularly responsive. So I just think there's going to be, you know, increased complexity for executors. I think HMRC are already kind of getting their act together, aren't they, in terms of investigations where people are undervaluing estates to avoid paying inheritance tax, not realizing that, you know, somewhere along the line there may be issues that come to light. Identifying beneficiaries, being really clear on that. Personal liabilities of executors, I think, are going to increase quite significantly. I think more estates are going to fall into the requirement to claim the residence nil rate band allowances, which requires full reporting regime as part of the IHT 400 process for estate administration. There's a 15-month pension fund release deadline that they have to work within. It's just going to really add some, you know, a lot of complexity to estate administration. I still think, as I say, there's benefits in clients appointing people they know and trust as their executors. As a family-led business, you know, very much our ethos is about keeping families in control of their own destinies as much as they are capable of, but they are going to look for additional support and guidance, I think, in terms of estate administration. And we can work with you to provide probate assistance services at very competitive rates. I do think there'll be an opportunity for some providers to overcook their rates on some of this, and I don't think that's necessary. I think it's about providing services to clients where they may be able to do certain elements of the process themselves, and they may just need support in certain other aspects, and that's about tailoring support as you do with your financial services model for clients, so they receive no more than and no less than what they actually need. I think estate administrations are going to take a lot longer, which is going to be interesting because beneficiaries tend to want their money once they've got a whiff of some cash. So that's going to create some pressures, I think. But interesting times ahead, and I'm sure you're all having conversations with clients around pensions and things like that. Any questions? Time goes so quickly with these, doesn't it? Okay, so on the agenda, I think, for everyone, pensions. Another thing I wanted to just bring to light, I think things like real life situations and scenarios always bring all of this to life. A lot of clients you come across will sort of say, well, great, you can help me with my lasting power of attorney, so what? Or, yeah, I know I need to make a will, but I'll get round to it. And often, in my experience, it's about bringing scenarios to life. So it's not necessarily about being very doom and gloom about all of this. As I said at the start, it's about giving the client some support and practical guidance in carrying out an administrative process. So some people kind of put this off because they fear, something's going to happen to them. Immediately the Grim Reaper is going to be knocking at the door and the end is nigh. It's not that at all. I can confirm that many of our clients have led very long and happy lives after speaking to us, but it is just an administrative process that they need to pin down. But they don't talk about wills and LPAs every day, so it's hard to understand how it's relevant. Also, a lot of clients will say, well, it's okay. I'm going to leave everything to my children. They will never fall out. They've always got along. They're lovely. We've got a great family dynamic. Brilliant. Well, you can tell them about the McDougall family dispute, which is very sad for the family involved, an absolute corker in terms of where things can go wrong in terms of estate planning. And there's a mixture of aspects at play within this. So fundamentally, there was a mother, there's a bit more to it. And as I say, anybody who wants more detail on this, quite happily send you some of the reports from the court, because it's really interesting reading. It's like a soap, TV soap, it really is. So the mother was thought to have an estate of something like, around 5 million, something like that. And when she passed away, it came to light that her estate was worth something like 2.5 million. So still a substantial estate. But in the lead up to her death, Mrs. McDougall had suffered with Alzheimer's and she had started to lose capacity. So her daughter was appointed as power of attorney. So that's one element. The client did make a will, and her original will, when she had capacity, or was thought to have capacity, the will was kind of fairly distributed, and the son was expecting to receive a couple of properties worth about 2.6 million. Then there was a later will that came to light that was put forward, really leaving the majority of the estate to the sister, and really only a small proportion, shall we say, to Gary, the son. So with the will side of things, there's a question about capacity. So when mother made the second will, did she really have capacity to do so? So there's a challenge on that element. Was there undue coercion? So did the daughter unduly or inappropriately coerce mother to change her will? There's all sorts of questions about when the second will was drafted, who took the instructions, was the previous will reviewed? Because if there's a big departure from previous will making patterns, usually that's a signal that there could be an issue. But as well as question marks around the validity of the will, which are quite interesting to observe, the daughter, it came to light in her role as attorney for mother, rewarded herself for that role fairly well, and spent a good couple of million over the 8 years that she was filling that role. What did she spend that money on? Well, it included luxury travel, dining at the Ivy, a Jaguar, very nice car. It also paid for her wedding at the Savoy, which was very nice, wasn't it? And the daughter said, well, it's what mother would have wanted. So, she would have given me that money if she'd have had the capacity anyway. So I don't see what the problem is. And this kind of comes through to not only kind of educating your clients about the importance of estate planning and understanding the importance of having wills and so on in place, but also having the opportunity to articulate why they're important to other key people, so executors or attorneys, because these are also additional people you can speak to for your financial services work as well, seamlessly linked. Because what we're talking about today is really you providing this holistic advice. You're going to be this kind of central source of truth. And even if you don't deal with some of this directly, you've got a bit of an oversight and insight to know how things can go wrong. But also it's about expanding your network as well. In this instance, in terms of the role of an attorney, fundamentally, the attorney is supposed to act always in the best interest of the person making that LPA, so the donor, so the mother in this instance. It's not about the individual choosing to reward themselves. There are strict rules on gifting. These are legally set out. They are not kind of flimsy guidelines. These are legally set out as guidelines under the Court of Protection. And clearly the daughter did not kind of follow these guidelines. And saying I didn't understand or I didn't know, according to the court, is not considered a good enough excuse. If you're looking to undertake the role of an attorney, you need to understand what's involved with that. So there's some practical aspects to consider, and as I say, it's about not only educating clients but these key people that they're going to appoint as well, and expanding your network. But fundamentally, an attorney on an LPA is not a beneficiary in waiting, is the general rule. The attorneys are there to act in the best interests of the donor as if they were them. It's not to spend money on themselves. So it's about, when we're kind of speaking to clients about lasting powers of attorney, we're not just completing a form. There's quite a bit more to these documents than you would think, because as we can already see, they can be abused. They can actually create financial abuse by attorneys. So we need to make sure the client is clear on the power of these documents, and making sure things like their wills and their LPAs align. So if there are, for example, gifts in a will, is it useful for the attorneys of an LPA to know about that? So the attorneys, for example, don't sell those gifts to raise funds, and then the person who's expecting to benefit in the will doesn't. So there's things like that to consider. As well, within LPAs, we can put some preferences and instructions in there. So if the client is looking to appoint attorneys who are okay with money, but maybe don't have a financial advisor themselves, I'm not well versed with investment matters, is it worth us discussing with the client, including some preferences or instructions to say that the attorneys must take professional financial advice before making investments decisions over 20, 50, 200,000, whatever it is, and naming their preferred advisor? Might be you, might be someone else. It's also about discussing with the client, you know, in terms of gifting, do they make regular gifts in this example already during lifetime? Is that something they would want to continue? It's about making sure that attorneys, you know, are fully versed, as I say, with what their responsibilities are. And also that these documents are reviewed regularly. You know, family dynamics, capacity issues, they can all change. It's not uncommon for clients to kind of ring us and say, well, I appointed my daughter and 2 sons as attorney, but my daughter, she's married this guy, we don't like him at all. She's made some really bad financial decisions. We want to take her off the LPA. So we can do a partial revocation and remove someone from an LPA. We can't add someone on. We'd have to make a new LPA if we wanted to add someone on. But it's just important to ensure that, you know, it is an administrative process that we need to undertake. But just like an investment decision, we need proper advice, or if we're renewing a mortgage, we need professional advice. There's a reason why professionals exist, because things can go very, very wrong if we take a bit of a do-it-yourself approach. You know, I'll just handle my own pension transfer, or I'll, you know, handle my own kind of investment strategy. And some clients do well with it, but there's always a reason to involve somebody who's trained, who has expertise in these matters. Now, from your perspective, that might be, as I say, linking in with ourselves. It might just be, you know, I've come across a client, I'm a bit concerned that there's some undue influence, or I'm a bit concerned this person's lost capacity, or they've made a will but they can't find it. Sometimes you might just need to sense check stuff. You know, you can always give us a call. It doesn't always have to be kind of firm business. We've worked with Julian Harris advisors for many, many years. We've got some good relationships with some of you, a number of you, and sometimes it's just useful to have a sense check, because these things kind of do happen. And whilst it's good, juicy reading, ultimately, where we get things like, you know, inheritance challenges that go through the court, well, that's going to massively erode the value of that estate. And the person who originally established the will or built up that wealth probably didn't intend for it all to go on legal fees and barristers' costs and so on, legal counsel. So yeah, just make sure kind of clients are supported, feel supportive, and are aware. They may already have, as I say, documents in place, and they just want to sense check things. So again, we can always review wills for free. There's no charge for that. And as I say, we're always happy to chat things through with you. Any questions? Really racing through. It's a good job you'll have a copy of the slides afterwards. Another thing I want to talk about was will trusts. So some of you kind of may have come across these, some of you may have not. They form kind of the framework and are a fundamental part of our kind of regular day-to-day work. So when we advise clients on making a will, where a client has a very straightforward family structure and they don't have complex affairs, then sometimes a standard will, trying to stop saying a simple will because I think it undermines things. A standard will can be sufficient. So they are going to appoint somebody as executors, maybe each other as executors, plus 1 or 2 other people, and they are going to leave maybe everything to each other if it's a couple, or they're going to leave everything to their children, and that's it. You know, quite straightforward. And that can be fine, but sometimes there are usually kind of family dynamics or scenarios or situations, or preferences or client values that may require a little bit more thought into how we structure their will. And that's where will trusts can come into effect. It's a way of directing a proportion, an element, or an entire estate with some further direction or discretion at a later date that can be taken depending on what the situation is at the time. When we talk about trusts, there are lots of terms banded around. We do it ourselves. We talk about things like property trusts, flexible life interest trusts, vulnerable persons trusts, children's trusts. But fundamentally, there's kind of three key structures that they are usually kind of part of. It's either a bare trust where there's an absolute entitlement to the assets. Now, you could say a will is in effect, is that a bare trust? Because the executors are going to hold the asset on trust absolutely for the nominated beneficiaries. Within the will, there might be something like an interest in possession trust, usually called life interest trusts. So is it that rather than giving an asset outright to a survivor, for example, the person might say, well, I want to give my share for that person to enjoy for the rest of their life, but I want certainty that my share will always go to my nominated beneficiaries, regardless on whether they remarry, maybe unduly influenced in the future, go into care, whatever it is. I want to know that my share is going to be protected. So that's when we talk quite a lot about life interest trusts, very common approach. And then we have discretionary trusts. So discretionary trusts can sit in wills, as can life interest trusts. And so they become effective on death. We do, of course, have all of these options during lifetime as well, which is separate. So for today, we're just talking about will trusts. So as I say, the will contains the trust wording. So nothing changes. There's no change to legal ownership. There's no transfer of assets during lifetime, but the will effectively becomes the trust deed on death. And then that's when we need to enact the trust. So it can be useful where you've got potentially young beneficiaries, so potential beneficiaries who could inherit under the age of 18, or there might be vulnerable beneficiaries. So clients may not want to give a share of an estate outright to a vulnerable beneficiary, for example, because it could compromise means tested benefits. So trust can be useful. It can be useful to manage assets for future generations. So things like care fees, we are allowed to talk about it. With things like property trusts, we're never depriving the state of assets with life interest trusts and wills, because the deceased person has just chosen not to pay for the survivor's care fees, for example. We can go into that in more detail. It can be useful as well where you've got clients with larger estates and potentially children who inherit could have inheritance tax issues themselves. So it's about future planning. It could be that beneficiaries are just not that good at managing assets, and in the view of the testator and in the view of the client, could just waste it. So do we need to put some trustees in there to help that person manage those assets? We always need to look at, when we're using trusts, is there going to be an impact in terms of applying for the residence nil rate band, all of that. But fundamentally, the thing to always keep in mind, whether you're taking instructions or referring clients to us, is what is the client trying to achieve? And then from that, we can work up a potential solution. Some clients can be a bit resistant because they're like, I am not the Duke of Westminster. I do not need trusts in my will. I'm just your average working person. It's going to create complexity. And that's not actually necessarily the case. So there's going to be, whenever somebody passes away, there's always going to be a level of administration. People sort of say, well, I don't want my estate to go through probate. Well, if you've got assets of £5,000 or more, it will. And so it's not for clients to kind of be concerned or shy away. It's about letting them know that it's just going to form part of that administration process. So, what does it actually mean? Because kind of we talk about it quite a lot now, don't we? When we're talking to clients, we'll say, well, look, Mr. and Mrs., you've got your family home. You want to protect that against remarriage in the future. You own it together. So if she dies first and he remarries, new spouse isn't going to receive the benefit, or her new spouse's family isn't going to receive the benefit of the first spouse's share of the estate. So they might say, well, we've got our house, Mr. and Mrs., 2 children, house is the main thing. We want to put a property trust in the will. So once one person dies, the surviving spouse doesn't receive the deceased share outright, but they have a life interest in the property. So they can treat the properties if they do own it, move, upsize, downsize, whatever. But the deceased share is always to be held for the benefit of their chosen beneficiaries. So in this example, children. So how is that actually enacted? How does that play out in real life? So what happens in those examples is that we need to apply for a grant of probate first of all, because if we've got a property trust, for example, in a will, or a life interest trust in a will, or a flexible life interest trust, then usually any property concerned would need to be held as tenants in common, because any property held jointly could only pass to the other co-owner. So because we hold property as tenants in common and there's other assets, we need to go through the process of applying for a grant of probate. Now, lay executors can apply for the grant, or they can ask for assistance in applying for the grant, whatever they want to do. Then once they've got the grant, then what we need to do is enact the trust that's within the will. And that means kind of there needs to be some kind of transfer to make it effective, but it's also providing some kind of audit trail. So for example, where we've got a property trust in a will, the first person's died, we've obtained the grant of probate, and now we're going to basically update the land registry to reflect that half of that property is now owned by the trustees and the surviving spouse, who will also be a trustee, and half remains in the ownership of the surviving spouse. So it's quite a straightforward process that we would undertake for the client. Now, because we've got a trust in place, HMRC will want to know about it. So they will need to notify the HMRC TRS service, woohoo, for those of you that know. And again, that's something that the lead trustee can do themselves, or they can ask for some support on that. That's no problem. So when someone passes away, it's not a case of doing nothing, basically. In any estate, I would say that we always need to review the will and ascertain, well, if everything was owned jointly, yes, it can just pass to the spouse. Do we need to do any deeds of variation? Is that going to kind of work? Or was there a trust in the will? Was there assets held in the client's sole name? Do we need to take some action? And that's kind of in the immediate aftermath. So it's kind of, as I say, there always needs to be something. On an ongoing basis, then the trustees need to just keep some good records. Now, if there is just a family home in the trust, nothing's really going to change unless that the life tenant moves. There's not any kind of income generating to declare, so no kind of tax to pay on it. But if anything changes, so any trustees don't want to act anymore, trustees die, just keep some reasonable records. And then the trust ends in that instance when the life tenant dies. It will automatically come to an end, and then the survivor's estate will be administered. So it's really just to give you a bit of an insight into that, because I feel like we often talk about, when we're discussing planning with clients, this is what we can do, and this is notionally what we do or what we include in the will. But it's kind of like, well, how does that actually work once someone's passed away? So hopefully that gives some insight. As I say, it's just one more step to the estate administration process, is what I would say. That, unfortunately, when someone passes away, there always needs to be something that needs to be done. Any questions on will trusts? Very quiet. Trying to keep this time. So we've talked about, changes to the pensions, thinking about inheritance tax, thinking about overall estate planning, having that broader, wider conversation with clients. We talked about how things can go wrong. So this family dispute, which, as I say, I would encourage you to look up because it's just an interesting read, and how it's one thing to get the documents in place, but they need to be done correctly in order to stand up to scrutiny, in effect. There's things like trusts we can talk about within wills for clients. So when giving a direct gift may not necessarily be the right approach. So we can already see that there's lots of ifs, buts, and maybes when we talk about estate planning. And it all comes down to, all of that aside, all the technical bits aside, court cases, processes, Mental Capacity Act, all Wills Act 1837, whatever, all that aside, it's about you as the trusted advisor to the client understanding what it is that they want to achieve. And these are naturally conversations that should crop up when you're discussing various updates or various aspects with your clients. So things like wills will naturally come up when you're completing kind of initial fact find and discovery meetings. As in our instance, where we're talking to clients who don't have financial advisors, when we find, I think we had one client recently who had something like, I'm not even sure what this is, a 2 million SIP pension that he'd been administering himself, amongst other investments. And I feel that's a very complex area. So we kind of passed him on to a financial advisor to help him with that. But naturally, when you start to have these conversations about financial elements, family dynamics, family relationships do come into play. And, clients make all these efforts to make these good decisions during lifetime and then just hope everything's going to be okay at the end. And as I said at the beginning, that's not right. It is about ensuring that we're covering off every aspect for these clients, because that is going to build your relationship. You're going to generate additional referrals, whether it's for wills and estate planning, pensions, investments, mortgages, whatever it is. It's naturally going to lead to wider conversations. You don't need to be a will writer to access estate planning support, and I'm pretty sure as a network who are very diligent with compliance, Julian Harris as an entity wouldn't want that either. But it's about trying to, give you access to these services in the most friction-free way for you and for the clients. So the clients have got that continuity. You're kind of their single source of truth, shall we say. There is an opportunity for additional learnings. If you refer clients to us, we do pay referral fees. If you look to take instructions, people build whole estate planning businesses alongside their financial services business. But more importantly, as I say, it really strengthens that client relationship. In terms of risk mitigation, we're not leaving any stone unturned, as it were. You've asked all of the questions. You don't necessarily have to have all of the answers there and then, but you've highlighted risks and issues to clients and given them an opportunity for those to be addressed. Often kind of people are hesitant because they think, well, I don't know enough about estate planning, or I do know too much, and that actually puts me off a little bit. But as I say, it's finding that middle ground and just having kind of a couple of simple questions with clients will open up a lot more conversations, whether that's about, have you thought about your will? Okay, you've got children under the age of 18, one of them's vulnerable, how are you going to provide for that person? Yeah, you could include a vulnerable person's trust in the will, but what about some income, additional income protection, some additional family benefit insurance, whatever it is in your financial services world, it's naturally going to open up wider conversations and just maintain that client relationship, because you don't want to be constantly chasing for new business, because it's quite hard. You want to build up a good client base. So from our perspective, there's a couple of ways of working with us. I know a few of you already do. If you have clients with any of these concerns or questions, or you're going through their pension review and think, oh my God, or going through, they may have a loss themselves, they may want to get their LPAs in place, you're just kind of busy doing your thing, then you can refer clients to us and we'll have that direct conversation with the client. We always keep you in contact, so we'll let you know when we've booked an initial call, or when we've taken an instruction, or what the client ultimately moves forward with. So you're always kept in the loop. So it's like having your extended estate planner. The other option is, if you think, well, this is quite interesting, then you have the opportunity to potentially be more involved in terms of the instruction taking process. So we can provide you with some initial foundational training. Some people go on to the IPW training. We offer quarterly just general updates to all of our associates. They're on Zoom as well. But you'd never be on your own. So it's about providing the right service for your client that's going to fit with your business, but using this as an opportunity to, as I say, widen and broaden that client conversation. So you're maximising every opportunity, but fundamentally you're just providing that good service to your client. I think that's largely it from me. I wanted to leave some time for any questions, if anybody has any. I think we've got 7 minutes. Mohan might allow us. Has anybody got any questions? Anything that we've talked about today? Any current clients that they want to just flag, experiences they want to share? Any thoughts about the pension changes from your perspective? Stunned silence. No?
Yeah, lots more to think about, Amy, especially with all the pension changes, taking place next year.
Yeah, I think there's going to be a lot that will come out of that that's not anticipated at the moment. I think at a high level, seems straightforward, doesn't it? But actually, as with all these things, the devil's in the detail and how it'll all play out. But I think it's just working together, keeping those communications open. And, if there are any questions, or if anybody would like a separate call or chat about anything we've covered today, or any specific queries they've got with clients at the moment, as I said earlier, sometimes it's just having a sounding board and a sense check. Always give us a call. It's never a problem. We're always happy to help wherever we can. All right. Lovely.
Yeah, it doesn't look like there's any more questions. Amy, thank you. Very useful again. Appreciate that. And we'll certainly distribute that out to the rest of the team. Yeah, thank you.
Great. All right. Well, thanks, everybody. If you need anything, you know where we are.
Thanks, Amy. Thanks very much.
Thank you.
Thanks. Bye, Amy. Bye.
Thanks.
Bye.